Right. Got my flag. Should fly my flag. Should be election. Yeah. I'm supposed to do that at the side, aren't I? Fly the flag. Do that in the future. All right. Right, someone's in. Got someone in. So that's always a good thing. We're going to get started in just a minute. Hope everyone can hear me. Right, I can see it now. So you can send your comments if you can hear me. And we're on. Oh, thank you, Tracy. It's always just so lovely just to know. So can you hear me? Can you just pop in there? Just say that if you can hear me clearly. Because I never know when I'm in the video if everyone can hear. So I hope you can. So we're on day 2 of the court hearing, okay? And this is the day that Wentworth is going to sum up. Now, all right, so everyone's getting angry with it. This is not really about, it's kind of about the whakaputanga, but it's not exactly. But I still have to give a little bit of background information to you just to remember that there, oh good, okay, just to remember that there are people that come on here that are new and they haven't heard a lot of what other members that have been here for the last year. So we do have to try and help them so that they can understand. So you have to bear with me for those bits. And not only that, it's really hard for everybody at the moment because we're working between 2 worlds. We're going to go back into the past and we've got to do some stuff there, and then we've got to come back into the future and we've got to do some stuff here. So it's like we have to kind of recap of where we are with it all. So when we look at the future, where are we now? We're on Sue Gray and we're on the United Nations infusing all their laws into New Zealand law through tikanga law and through the fate tiriti. So we're on that at the moment, and we've got to, and we're also realising that we've been taken out of British law against our will, without our knowledge, and we've been placed into American law. And then when we go back into the past, we did the John Dunmore Lang letters, and we're up to, the treaty was already signed, and then 3 or 4 months later, there was a court case, and there are letters about the court case. All right, is it going on the funnels? Yeah, I think it's all right now. Right, so, all right, they're back now. So it goes on the fast, doesn't it? So now we're on these letters, but I just want to tell you that I did do a video, and I just want to recap for the new viewers that there are actually 2 whakaputangas. One whakaputanga was written by Busby, and another whakaputanga was written by Manuka Hanari in 1986, which replaced the original. Now, I just want to tell you what the new before we start the court case, I want to tell you what the whakaputangas were. So in the old whakaputanga, in section 1, it says, we the hereditary chiefs. And in the new wakamanenga that they call it, or something, in section 1, it says, we the absolute leaders. In the old whakaputanga, the original, it says, the sovereign power lay with hereditary chiefs, which means they have to be born to New Zealand at least, in their collective capacity. So that meant that all the chiefs would govern together in a collective capacity. And the new one that was done by Manuka Hanari in 1986, section 2 says, sovereignty lay with the kingship of the kingitanga, and it belonged to the true leaders. And we don't know who the true leaders are in the present day one. In the old one, in the third article, it says, we, the hereditary chiefs, which means they have to be born to New Zealand, agree to meet once a year. In the new one, in section 3, it says, we, the true leaders, who we don't know who they are, agree to meet every year. So there's quite a bit of difference there. And then the fourth bit, which was written by Busby, and he said, we will write a letter to the king thanking him for the flag, and that we, New Zealand Aboriginals, they called them, we Aboriginals will provide protection to his king's subjects. And whenever you use the word subjects, you're giving them the protection of the 1688 Bill of Rights. That's the protections that you're offering to them. But in the new one by Manuka Hanari in 1986, says they removed the word subjects and they called the Anglo people Pākehā, which is significant because it means that in the modern day one, that the our English rights were removed from us by these absolute rulers that we don't know who they are. Now, I just want to tell you about one other law change that's in the modern time that I did do another video about the Magna Carta, which in the preamble, the Magna Carta, the popes, the knights, the kings gave themselves absolute power over the English tribes in perpetuity forever. And nobody was allowed to own land unless they belonged to one of the churches. Either that you had to belong either to the Jewish church or you had to belong to the Catholic Church. So that was the only way, or even the English church wasn't established, but you had to belong to them if you wanted to own land, was the rule. And anybody that owned land, which were from those two religious groups, they were called, I hope that's good, they were called, until it comes back on. Is it cutting out? If it's cutting out, just let me know. Okay, so I think everyone's there. Looks like it's cutting out. All right. Okay, sorry, I get a bit lost there. So this Magna Carta, it was section 29 in the Magna Carta that was not for the English slaves. It was only for the English kings and the popes and religious leaders. And they wrote themselves a law to say that nobody could take their lands without a jury to judge it. That was for them. It wasn't for the commoner people of England, right? Now, in this law, the Magna Carta was never in New Zealand law. And we had the 1688 Bill of Rights, which also has a law in it, which is a little bit different to the Magna Carta, because the 1688 Bill of Rights law applies to all people in New Zealand, that the government couldn't take your land without, I don't think you had to have a jury, but they just couldn't take your land anyway. Yeah, I think they had to have a jury. But the Magna Carta version was instituted into New Zealand in the year 2000. And it was also instituted into Australian law in the year 2000 in the states of Victoria and all the states where they're having all those problems now. The Magna Carta was instituted of section 29. But the preamble was not in New Zealand law, but the preamble went into Australian law, giving the Pope absolute rule over all of the people. And that went into Australian law in the year 2000, and it went into New Zealand in the year 2000 also. Now, this letter, now I need you to remember that, because it's going to come up in the end of this letter that I'm going to read to you, why that particular piece of information is important. So here's Wentworth's summary. I'm not going to go over what I did in the first video, but I'm just going to say what Wentworth's summary is. So he says, 1, the proclamation, which was the treaty that was produced, he said, in Sydney and New Zealand. So there must have been a treaty done in the courts of Australia, and there was a treaty also done in New Zealand at the same time. And he says both of them were not valid. Now remember, Wentworth is fighting to keep all of his lands. He's saying that yes, the Crown can come, but the Crown should not confiscate any lands pre-1840. And remember that the missionaries had bought all the lands, so there was nothing left there for the Maori, very little. But the Crown was fighting, and they said, we're going to confiscate the whole lot, and we're going to investigate all of it. And this is what Wentworth is fighting. So he said that the proclamation to take all of the lands and put them in the land court was illegal. He said those laws were made in Australia. He said that the American Indians exercised their right to sell land, and New Zealand Maoris also had the right. He said the American Indians exercised their right to sell lands, and the New Zealand Maori had been denied their right to sell lands. This was his argument. He says that the removal of that right from the New Zealand Aboriginals was in opposition to British law, and that Britain was silent about it, and that the right was recognised by the law of nations. And he's talking about, okay, and he also said that the law of nations proved that it was acceptable for British subjects to form colonies as well as British kings. So he said it's not only the kings that are allowed to form colonies. Anybody can go and form a colony as long as the chiefs agreed. And he's saying the chiefs agreed with the missionaries to let them form the colony. So therefore, and the chiefs agreed with the missionaries to let them buy all the land through the whakaputanga when that was signed. So he says, A, the Crown has got no right to form a colony because they've already formed one that was agreed by the chiefs. And he said, and B, the Crown have got no right to confiscate the English subjects' lands because that was also agreed to by the chiefs that had the right to sell. Okay, this is it. So he said that they had the right, and he said that according to the Magna Carta, he didn't use the 1688 Bill of Rights. Now, the whakaputanga was tied to the Magna Charta or the Magna Carta because of the papal rule and the missionary rule. Whereas the 1688 Bill of Rights is tied to the Treaty of Waitangi because in that one, religious leaders can't govern over us. So Wentworth did not use the 1688 Bill of Rights because he would have lost his case. So he had to use the Magna Carta, and he used Section 29 that was never a part of New Zealand legislation until 1980, in the year 2000, around about that time it was put in. So there's a lot of trickery going on at the moment, but from the past and to the present. And if you can make all these connections, it's a bit complicated, but if you can make these connections, you're going to say, oh, there's something really stinky going on here. Yeah. So in the Magna Carta, Section 29, it says, no man can be deprived of his lands without first having a jury to judge it. And then he goes on to say that the jury could not bring in a jury to judge it because the Court of Britain was only established in 1840, so they couldn't establish a jury to judge anything from pre-1840 because they didn't have any court. So that was another one of his arguments. Having that established, that the natives had the right to sell the land, the next thing that he would like to inquire about is if the British had any law to prevent British subjects from purchasing land from a native. And he said he had searched high and low, and he could find no law in Britain that said that British subjects couldn't buy land in other countries. So he said, is there any law? And he said, there is a law that if a British subject is allegiant to another country, then they can no longer keep their privileges in England. But he said, since by 1840, in 1840, New Zealand was going to be a British colony, therefore that law would not apply anyway, because they could keep their lands, and Britain would make it a colony, and they would get to keep their lands, and they would get to have British privileges and British rights as well. So he basically wanted his cake and eat it, really. A little bit sneaky. It's funny how when it suited him about the lands, that he didn't recognise the court hearings of Sydney and the bill signed in Sydney, and yet when he wanted to keep his British rights and his British privileges, he suddenly called up the very law that he had just said was invalid. So there's a little twist there, isn't there? He said that his last complaint was that the South had very few, So his last complaint was that I love to see those thumbs up because it helps me know that everyone can hear. His last complaint was that the British government had said that the South Island had very few people and that they were not clever. And he said, so therefore they claimed their right of discovery because they said that the tribes in the South Island being so few, they weren't able to make governmental decisions for themselves. So they claimed right of discovery. And he disputed that. And he said that he could show that, in fact, they were more clever than the North Island Maori and that they were building things. And he said that they were working on the boats and they were collecting money and they were living very similar to the Anglo people, an Anglo lifestyle, a very peaceful lifestyle. They were working every day. And he said they were more clever. And he said most of them even spoke English as well, which was unlike the northern tribes. He said, however, he said he wasn't going to pick on that at the moment. He was mostly going to pick on that the British government had no right to investigate their lands that were purchased pre-1840. Now, we're coming to the end. It's going to be quite a short video, I think. Is it going to be a short video? He said that the bill was nothing more than a land confiscation to take property away from the missionaries. Well, they weren't really missionaries, but from the British subjects that had settled there, and do away with all the property that had already been acquired by the British subjects. So he said that's what they were doing. It wasn't the Maori fighting this. The Maori had sold it all. It was actually the white missionaries and British subjects that were fighting this land confiscation, actually, not the Maori or the Aboriginals. I keep calling them, I always call them between Aboriginals. So any act, he said, passed to take land for public purposes, for the Public Lands Act, would be illegal. And any compensation must be decided by a jury, as by the Magna Carta. Therefore, the New Zealand bill was repugnant to the law of England. And he said council must not pass the bill, which is the treaty, and the judges must not certify it. Now, I'm just going to put in my own Kate Floss gumboot lawyering vocabulary here. The Treaty of Waitangi was just a ceremony. It was already judged and it had already passed in Sydney before it even got to New Zealand. It had already been discussed and passed over a 5-year period in England. In fact, it had been already passed several years ago by the king, but he died and it fell by the wayside. And so then it came up again, but it actually had been passed. And this Treaty of Waitangi had been going through the courts in Australia and England for more than 4 years before the actual signing. Now, even though it was signed in February, that didn't even still make it legal. That was just a signing. Then they had to set up a court, and then that actual treaty had to go through a New Zealand court and be passed as a bill. And so that is when it became law. Not even at the signing did it really become law. It had to be passed as a law, as a bill in the New Zealand court, and then it had to be sent to Australia, and then it had to be sent to England for the royal seal, and then it had to wait for 2 years before it actually became binding in law. So I don't know why you're all saying that this treaty isn't binding, but so he said that the council must not pass the bill, and he said that the judges must not certify it. So if the judges didn't certify it, then it wouldn't have been sent to England. It would never have been stamped by the royal seal, and then it would have been out the window. But obviously the judges did sign it because it wasn't out the window. So the bill said no claim. And part of the bill that he was opposing was it said that nobody was allowed to make any claims on the seashore or the rivers or the headlands, which I'm assuming headlands is forestries. And if you look in the Treaty of Waitangi, if I've got it here, get a bit sidestepped. Not in the treaty, but in the English version of the Treaty of Waitangi, it says that confirms and guarantees to the chiefs and tribes of New Zealand and to the respective families, which means the Anglo settlers as well, and individuals, which is the Anglo settlers as well, thereof, the full, exclusive and undisturbed possession of their lands and estates, forestries and fisheries and other properties. So this was removed from the treaty. And so the bill forbid any of the land claimants to the foreshores, the harbours, or the towns, or the forestries. They weren't allowed that, but they were allowed to have claims like on farmlands if they wanted to have a farm, because that would produce food for everybody. And the Maori, Lord knows the Maori needed some food. So farming was a good thing, wasn't it? But they said, you know, you're not having these foreshores and you're not having all these forestries because that actually belongs to all the tribes. And this is what he was contesting. We're on the last bit. We're on to Hobson now. And Hobson asked him one question. Yes. Hobson said to him, how much land did Mr. Wentworth hold? And Mr. Wentworth said this. Listen up, everybody, carefully. He admitted to owning, in an approximation, the entire South Island. He admitted that he owned the entire South Island with him and his associates. And he admitted that his associates were 5 or 6. I mean, he's lying, isn't he? Obviously, Mr. Wentworth, because, you know, if you've got a company that owns an entire South Island of an entire country, you're going to know if you've got 5 or 6 people in your little corporation, aren't you? So he's kind of hiding something. He says, and he said it was only approximate too. So he was careful not to lie in the court. And so 6 people maximum owned the entire South Island, according to him. And he said, but now the New Zealand company was making a claim on half of it, all right? And he didn't want to give up that. He also said that he owned, in his claim, more than 20 million acres of New Zealand land. And he also, this was only in the south, He also had possessions in the North Island that he didn't disclose how much those possessions were. So we're talking about, so had he have won his case, but he didn't, but had he have won it, then he would have basically owned the country. So you, New Zealand Maori, need to give a huge thank you to Her Majesty Queen Victoria. And it's no good beating up on poor Queen Elizabeth, Majesty Queen Elizabeth either, because she's just born to it, and she's kept that for you all these years until 1986 when they threw her out and took it all. Now, I just want to ask you this question. We're about to finish. I want to ask you to think about these questions. We'll come back for the next video, but you can all send me messages. I want you to answer me these questions. Do you think pre-1840 that the New Zealand natives had the right to sell all of their lands? Do you think that? Number one. Number two, if the treaty would be to be removed in 1986 or completely removed from New Zealand legislation, if it was completely taken out, and the whakaputanga was to come back into power, answer yourself this question. Who do you think the land is going to belong to? Do you think it's going to all go back to the present day New Zealand Maori? Or do you think that if they approved in 2000 that Magna Carta was correct and that everything was correct, and that if they made the court case of 1840 illegal and appealed it in the modern times and won the case in the modern times, who do you think all that land's going to go back to? Well, of course, dingleberries, it's all going to go back to Mr. Wentworth and his mates, his 5 mates, and their descendants. And Mr. Wentworth has a mausoleum in Australia, and his descendants are upkeeping it. And Samuel Marsden has got descendants in New Zealand. And I just saw on one of the fisheries settlements who was on it. Reverend Samuel Marsden, who is a direct descendant of the original Samuel Marsden that was behind this whakaputanga and all these land sales. So I'm just saying to you, you all got to be thinking about what you're doing when you're flying. When you're flying that 8-pointed flag and you're saying, whakaputanga, whakaputanga, if that treaty is gone and it goes back to the whakaputanga, all those original land deeds are legal and binding again, just as they were right back then in 1835. And let me tell you something, those land deeds didn't belong to the New Zealand Maori. No, they didn't. They belonged to all those missionaries that came and brought it all up. So I want you to think carefully about all of what I've said just now. And day 3 of the court hearing is coming up, not today, but another day. Thank you very much, and goodbye.